So there's this big case coming up at the ConCourt, Zuma versus the IEC.
However, the sentence that was imposed on Zuma of 15 months seemed to me to be tactical. It seemed to me that the 15 months was chosen specifically because it goes over and above what someone needs to have to be able to go back to the National Assembly. To me, it seems as if the crime of assault with grievous bodily harm is more serious than walking out of a court. Did the IEC have the jurisdiction to make that decision?
Spread the fire. Welcome back to SMWX. And today I'm really excited to be joined by analyst, both political and legal, Mighti Jamie. Bro, thank you so much for joining us on SMWX.
Pleasure to be here.
So there's this big case coming up at the ConCourt, Zuma versus the IEC. And before we get into the case itself, how do you analyze just the significance of this case and, how it fits into this election?
First and foremost, let me say I love Jacob Zuma and his legal strategy.
You see
right?
now.
And his legal strategy together. Take it together. Why? Because one, it brings so much attention to the law, to the institutions,
That's so true.
to the technical aspects, which the last time I saw that happening to a great deal, right, was with Oscar, to an extent with Senzo Meyiwa.
Yeah.
But Zuma always brings that gaze. And I think that's important for just entrenching legal knowledge, entrenching understanding of the institutions. And because Zuma is bringing these constitutional matters to the forefront, many people learned about rescission from him.
Sure.
And people didn't even think it was possible to make that kind of an application till his legal team did that. And I think that's important. So I think in and of itself, that is something that is valuable, which makes me like this case. But the fact that it's happening at such a critical moment in the South African election, that worries me a little bit because things could go left. And I'm concerned about the different motives, the different feelings around this case, because people are not fully approaching this case from a position of objectivity, of neutrality, and even scholarship. There's a lot that gets put into the pot when you're close to an election. Even if you think about Trump, right, and the case that's happening there,
Sure.
there are some questions which are being asked about the second leg of this Stormy Daniels trial. Because on the first intent, you have to show a conspiracy, but you have to show a conspiracy to conceal a second crime. And thus far, there's been no legal argument to the jury about that second leg. And there was an article in the New York Times which actually spoke about how this case is actually bad fundamentally and should never have been brought. But because it's an election year, because so many people hate Donald Trump viscerally, many people are willing to ignore those legal nuances to simply hear the story that Stormy Daniels has to tell, just to simply show him in that portrayal where he's on trial, he's criminally on trial, because they think that that helps them for the November election. I think in the same way that we can appreciate that the emotions are heated in the United Kingdom, we can appreciate that the emotions are heated in South Africa as well. And many people like to come as if those things are not a dynamic, but they are a dynamic. There are issues. We know what happened in 2021. And I think people were flippant in 2021. They ignored what was possible because some of the people asked the question to say, what are the consequences of this? And everyone said, no, rule of law, Zuma is not above anything. When they knew that de Klerk didn't face the full rule of law because there were other factors that had to be considered, which is why we ended up with the TRC, which is why we ended up with some of the compromises that we ended up with, because we recognize that if we try to get full retribution, this will not work. And Azapo even took the case to the courts to say, no, but we want retribution. We want justice. And they were told, listen, reconciliation in this instance is more important than retribution. So all of this is to say this case is not happening in a stable environment. It's not happening in an ahistorical environment. It's happening after 2021, featuring the same man from the 2021 events.
Absolutely. And, people's political persuasions, even their love for Zuma as well, to be fair, clouds this case. And so you've got one side of people who will completely, support Zuma no matter what he does. But you've also got this other grouping which will basically find any way to
Zuma must go forever.
Whatever the legal consequences. And I hear you. I think just in general in the public debate and in the media debate, we just need to take the heat out of it for a bit and just try and analyze this from multiple perspectives. And I hear you with the PW Botha, de Klerk, Mandela situation. Let's come on to the case then. And how would you summarize what the key issues are in the case?
Well, what's going to be determined by the court, I think, as a plurality of issues. In the IEC judgment, they rested their understanding or their decision on 5 elements. But I think key elements that are going to be important, number one, is going to be the question of, did the IEC have the jurisdiction to make that decision?
Sure.
What we saw in the first 2 judgments is that it was very clear that the judges said, hey, listen, we agree. The IEC did have the jurisdiction to make that call. An interesting argument was asked about whether or not, if someone is awaiting a sentence but they've committed a crime, can they be these are interesting legal questions. The other one will be the definition, right? Or not the definition, the interpretation rather of the purpose of Section 47, right? In terms of what really is the purpose in the context of somebody who does not have access to an appeal.
Absolutely.
Because that is going to be something critical. And then also there are going to be some interesting legal questions around interpretation, right, of separation of powers. Because part of the remission arguments are that, the president cannot undo from a political office the purpose of the judiciary. And in doing what he's doing, he may have created an anomaly if they were to rubber stamp the interpretation of Zuma's lawyers that the rescission, reduces, not the rescission, sorry, the remission reduces the effective length of the sentence and therefore changes whether or not the sentence is now considered to be 15 months.
Yeah.
They'll be looking at that. And I'm going to be interested to see what they look at. But we know that there's been an application for recusal.
It's going to be big.
And that's something that I think is important just to unpack.
Let's come into that exactly, because that'll probably be right up front.
That will be up front. You have to start with that.
Exactly.
Yeah.
And talk me through what you're thinking on this recusal point, because I think it's going to be central to the hearing.
So just for those who are like a little bit interested, who want to go and check what the case is, you can Google this and get the information. The case is President of South Africa versus the South African Rugby Union.
Right.
This is where the test. Yes, exactly. But if we say that, people are not going to, if you just say SAFU, lawyers, they like to speak in, they'll be like, we'll add idiom about this. And then the audience is like,
add idiom about SAFU.
What is ad idiom? What are they talking about? They'll be like, in limine, he needs to say this in limine. Like people are like, what is in limine? I'm a lemon, So let's, but anyway, that's the case. Go check it out. So there's 2 legs of the test. Number one, that you need to have an apprehension of bias based on the perspective of a reasonable person in the position of the litigant. That's number one.
Right.
And number 2, that bias has to be based on, that reasonable apprehension has to be based on reasonable grounds. So I've seen some Sunday Times and a few other places saying there's no basis for Zuma to have apprehension. But I don't think he's unjustified in making the argument that he does. Because when you go back to the original judgment, right, the one that imprisoned him, that caused all of these problems, some of the rhetoric of the judges seemed to me to indicate that they don't like this man, right? And I'm gonna give you an example here. Paragraph 48. This is what Kampepe said. A coercive order would be futile and inappropriate in these circumstances. Coercive committal through a suspended sentence uses the threat of imprisonment to compel compliance. She's trying to explain why they are not ordering Zuma to appear again, but with the threat of imprisonment.
Sure.
So almost a suspended sentence pending an actual, imprisonment sentence. So then this is what she says. It is incontrovertible. It's a strong word. incontrovertible that Mr. Zuma has no intention of attending the commission. I think that went a little bit too far, because they are basically saying that this guy Siyamazi, he's not going to do it. And you cannot be prophetic in the law. You have to adjudicate conduct as it happens. But the fact that the court was willing to start making predictive analysis, prophecy, Prophet Isaiah, Prophet Jeremiah, your Judge Kampepe, not Prophet Jeremiah. So how do you know what the man is going to do? To me, this concerns me. Then they went on to say, paragraph 50, Mr. Zuma has demonstrated a marked disregard for the authority of this court and is resolute in his refusal to participate in the commission's proceedings. Thus, it is impossible to see that a coercive order would achieve any of the purposes of contempt proceedings. So they were using language that seemed to be hostile to him. So if you were a reasonable person in Zuma's position, going back to a court that admits in its own judgment things like, I acknowledge that the decision at which I arrive, namely an order of direct committal, may constitute an unprecedented step forward on the trajectory of contempt litigation. But because it's Zuma, I'm going to do it. Paragraph 58. Although I acknowledge that for the most part, our jurisprudence has left me up the creek without a paddle, I must say it is perilous to rely on irrelevant precedent. So he's saying, I don't have precedent. And all of the precedent that has been presented by the dissenting judges, I'm going to say it's irrelevant. That to me seems as if it's an overcommittal to one side.
Yeah, and the key point here is that some of the very individuals who sat in that decision and who concurred, and indeed those who didn't concur, are also sitting in this case. And so we've got a situation in which there is undoubtedly an intersecting set of facts, right? Because the facts in that case bear on this case to some extent. Now, there are other facts that have happened subsequently, but we've got an intersecting set of facts.
Yeah.
And we've got the same individuals who have to think about those facts. And so Zuma is saying, well, you already took a position on the impact of those facts there.
Yes.
And I'm therefore reasonably suspicious that you will have the same kind of impression as the facts bear on this case.
Yeah, there's a reasonable apprehension. I think to consider that some people can look at this and say, wait a minute, if these people don't like this guy and they've ruled against him, he's going back to them again to ask them to consider that the first sentence that they chose was the wrong sentence and that there needs to be a reinterpretation of how that sentence is. I think that is something that we can agree that there's a case to do that. And before we even go on, there's something that needs to be discussed here about the original judgment and how it came to be. And firstly, the decision to take Zuma to the Constitutional Court as the court of first instance for him walking out of the commission was irregular. It was an anomaly. They should have gone to the High Court. And this would have rectified all of the mess that we are now in. But they said, no, we're rushing there because this thing is important. We want to be able to get Zuma to appear. That's what they said at the beginning. Then at the end, they now said, while it's important for Zuma to appear at the commission, it is more important to assert the authority of the court. But all along, you've been saying it's important for him to appear at the commission. And then later, the commission reports were delayed by a significant amount of time. So then you're like, okay, so what was the hurry? You created the impression of urgency and then delivered the result very late. So how can you assert or allege that there's urgency? So when I looked at the thing holistically, I was like, the argument around urgency no longer seems to be legitimate. It seemed to me that the chairperson of the commission, Deputy Chief Justice Zondo at the time, went to a forum that was favorable to him and a forum of judges who knew that this guy could be our boss in a short space of time. And he had influence, even though it was soft influence. He was their supervisor. So your supervisor comes and says, hear this matter for me quickly. And then you say, sure, let's hear the matter. You rule in his favor. And then you create some anomalies. And people have not discussed this. Then the decision in and of itself to skip the coercive order, right? Because a coercive order, as acknowledged by Kampepe, the purpose of contempt proceedings, right, it's to correct the contempt so that the person appears in the first court. And she says this at paragraph 47. A coercive order gives the respondent the opportunity to avoid imprisonment by complying with the original order and desisting from the offensive conduct. Such an order is made primarily to ensure the effectiveness of the original order by bringing about compliance. What compliance? The compliance of going to give your version or to respond to questions that may have arisen as the testimony was presented at the State Capture Commission. The commission which you said was so important. Billions were lost. Now you're saying, no, the authority of the court is more important than getting to the bottom of state capture, which we've been told was the biggest thing to ever have happened in post-democratic South Africa. How does that work? So I think that is something that we mustn't forget.
So of course, I mean, at the end of the day, the court found what it found and it's now law, right? But it bears on the recusal point because of the overlapping facts.
Yeah.
Zondo has already recused himself, and I think that's interesting. What do you make of the fact that they've asked for Tehran to recuse herself as well? Because she actually found against the majority, so for Zuma. And I think that's an interesting aspect of this that people maybe haven't appreciated. I've seen some saying, oh, well, how can you ask for Tehran to recuse herself? But that would seem to be consistent. You shouldn't have a view on the facts either way, one way or another.
Yeah, and I think maybe that they're doing it that way for completeness.
Yeah.
To say we don't want bias in both directions,
Sure.
right? Because if we just ask the people who are hostile to us, that wouldn't make any sense. We have to ask both sides of the equation. So I think that's critical. But also, I think Theron made a lot of technical points in the judgment, which maybe also we're like, oh, this judge is not really for us. She's more for the principle than us, the individuals in this particular case. And that principle being that Zuma's constitutional rights were violated because typically you would need to have access to some form of appeal, which is what led to the creative attempt to get a rescission.
Let alone cross-examination.
Yes, there's
evidence.
a lot that didn't happen, right? And of course, contempt of court is a crime. Nobody's disputing that. There's something I want to add here about this crime of contempt of court.
Okay.
Is it worse to beat somebody with a pistol or to walk out of a court? What do you think? Because Mandla Mandela was convicted of pistol whipping somebody. He committed a crime. There was some traffic incident. He took a pistol and he fired somebody in the head. Pa, 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 pa. Right? He was sentenced. Under 12 months, he was able to serve in parliament. Zuma walked out of a court. To me, it seems as if the crime of assault with grievous bodily harm is more serious than walking out of a court. However, the sentence that was imposed on Zuma of 15 months seemed to me to be tactical because the Commissions Act has a sentence of 6 months, right? Up to 6 months, if I'm not mistaken. So why was it so imperative that the court says to Zuma, a man who was elderly, that they were familiar with some of the facts, to say, we are sending you to jail for this period of time? It seemed to me that the 15 months was chosen specifically because it goes over and above what someone needs to have to be able to go back to the National Assembly. And that's something that just makes me uncomfortable about this whole thing. You know, in South Africa right now, there is a cognitive dissonance which is occurring, Sizwe. And this is the dissonance. When people look at the American Supreme Court, they can appreciate that Donald Trump played a role in the composition of that court such that it leans towards the right. And the results of that right-leaning Supreme Court have already started manifesting in America, right? People appreciate that. People even appreciate that the decisions being taken by the New York judges as compared to the Florida judges are different. The Florida judge just delayed the Trump case, whereas the judge in New York has been very harsh, issuing multiple rulings against Trump, even as the court process is unfolding because of the things he's saying on social media. So you can see that the Florida judges lean to towards the right and the New York judges lean towards the left. You can see that the Supreme Court now leans towards the right. But in as much as they appreciate all of that, and in as much as they even may appreciate that in countries which are dictatorships like Zimbabwe, like Uganda, the presidents and the political parties that rule have influenced the judges and the selection of judges. In fact, Mugabe lost cases in the early 2000s and started deliberately changing the composition of the courts and aggressively intimidating judges who disagreed with him, to the point where after he remade the courts, all of the judges agreed with him, right? And he never lost a case. So that's something that people appreciate, that, hey, powerful people can influence courts and judges can lean one direction or another. However, there is this assumption that then exists that not in South Africa, not here, not here. Our judge is perfect. Our judge is inscrutable. Our judge is infallible. I think that's a very dangerous position to take, because we have to hold every institution to the same level of scrutiny and skepticism. We can't say this institution is beyond scrutiny, but the executive ask Ramaphosa every question, ask Parliament every question, but the judiciary ask no questions. These are all good men and women. These are all people without personal opinions. And yet at the same time, we are told that Judge Hlophe was operating in a way as a judge president, which was so egregious that he needed to be removed. So Judge Hlophe, you can see the wrongs of Judge Hlophe, but any other judge or bias even, you can't see their bias. That's something that's very dangerous. And I think we have to be careful about that, because we're going to then lose honesty in the conversation.
Absolutely. I think, an understanding of the intersection of politics and law has such a long academic history, and maybe we're a bit naive in our conversations here. And that doesn't constitute a, quote, attack on the judiciary. It's just a further nuanced analysis of what's happening in courts and the politics and the internal politics at play. One interesting thing about that is also to think that actually, funnily enough, former President Zuma was probably in part responsible for the appointment of some of these judges as well, which is an interesting point. I want to come on to...
And he may have chosen some of these people because he thought, I know this guy.
Exactly.
I know Zondo, I know you go there and be a judge.
Meanwhile,
and then later on, he's like, no, but Chief, we spoke about this in the hotel. Now you don't know me.
Exactly. So just on this recusal point, there's an interesting point here which has been lost in the public debate, which is that Judge Daya Pillay sat as an acting justice in the ConCourt in one of the relevant matters here. She's a commissioner at the IEC, and she recused herself from the decision.
She recused herself like Love did.
At the IEC.
Yeah.
Because she sat on the Constitutional Court.
Yeah.
So why would she recuse herself and not these Constitutional Court judges?
Because she sees that, hang on, I'm actually conflicted and I have a view. Look, I think that the issue of recusal also has this thing that the person that you're asking, if they haven't self-selected to recuse themselves, then you have to say to them, but Chief, Chief. Then they have to say, no, I don't know. I am not going to do that.
Yeah.
Trust me. And this is one of the glitches, I think, generally in the legal system, that you have to ask the very judge that is overseeing the case to recluse themselves. And if they don't want, then what? Right?
Yeah, absolutely.
And this is where we're going to be. But I think the Constitutional Court should be very careful, Sizwe, about this whole situation, because the law must be done and seen to be done. But there are soft elements to rule of law that sometimes we'll discuss in jurisprudence. And the institution, especially the Constitutional Court, is there to uphold the integrity of the courts, but also rule of law.
Sure.
If you get to a point where you make moves and decisions where people no longer buy in to the legal system, that can cause problems downstream. Because you start to corrode the trust that has been built up. I know why people are always hesitant to attack judges or even to scrutinize judges. Is because the Constitutional Court, its activism, its interpretation of court cases has really advanced
Sure.
the rights of people.
Yeah.
It's really
Yeah.
acted in ways at various periods of time to advance the democracy. Even this thing of independent candidates, it's because the Constitutional Court
Yeah.
made a determination. So
when other institutions have
Yes.
often failed, especially the executive and the legislature.
exactly. So our respect is not unwarranted.
Yeah,
Like
absolutely.
a lot of the cases that you learn in law school and constitutional law, allowing for gay rights, blocking the death penalty, all of these things are critical.
Absolutely.
And they have a cachet of respect and gravitas.
Yeah.
But it's so easy. You can ask Drake. It's so easy to lose gravitas and cachet in a short matter of time, space of weeks. So the fact that this is happening at such a critical, volatile moment, I think that they have to consider the public impact. I think that in 2021, they were lackadaisical in considering some of these elements to say, what does this say for the integrity of our court? They should have considered some of the arguments that Helen Suzman Foundation made a little bit more carefully, I think, in the original case. And I think even now, they should be very circumspect around the fact that people are going to watch this case not with full conviction, but with question marks, with arms folded, with a lot more reticence than usual. And if they do not do everything in a manner that satisfies a majority, they could undermine the credibility of the institution, they could undermine rule of law, and they could squander in one transaction the cachet that they have built up over the last 3 decades. It's a very, very perilous moment. And I don't think that we should ignore that. I think that it definitely requires more care, more consideration. To be quite honest with you, if I were them, I wouldn't have taken this thing on an urgent basis. I would have left it because most of the things that need to be determined here are legal questions that can then be applied in future elections. I think that having potential to tamper with the choices that South Africans have in this election in a way that favors one guy over another, because we saw the polls. We saw where the ANC is sitting. If Ipsos is correct, and I think they're actually overestimating the ANC performance, if they're correct that the ANC is at 42 or whatever, and Mkhonto we Sizwe is at about 8, if you remove Jacob Zuma from being at the top of the ballot, that could affect Mkhonto we Sizwe. It could affect whether voters turn out. So maybe they drop from 8 to 4, right? Or maybe to 1. Then now, in a very tangible way, you may have impacted as a court the results of an election and people's rights to express their political choice. And that for me then becomes something very concerning. It takes me back to 2000 in America when George Bush and Al Gore had to go to the Supreme Court for a determination. And the Supreme Court basically gave George Bush access to that seat, which he didn't necessarily deserve. And I think there's been some evidence that this should have actually gone to Al Gore. It's now a subject of history. But there will always be a bitterness about that election within America. But imagine what this kind of an outcome could have on a very young democracy like South Africa. I'm concerned.
No, absolutely. I think it is important to reflect on just the sheer political significance of this case. And the ConCourt is in a tough position. Maybe it's placed itself in a tough position to the extent that it has to consider very complex legal matters of interpretation under conditions of urgency. And one would have preferred them to be able to have as much time as possible to consider these complex issues, because they're going to have to
without having a bearing on the choice.
Exactly, because they're going to have to make a snap judgment of very complex issues. One of them, before we come on to maybe some of the political analysis of this case, is this question of remission. I don't know what your thoughts are on that, but it's an interesting one, because as we analyze this section, and just to explain for people, there's a section in the Constitution where you can be disqualified from being in the National Assembly if you've got a sentence of over 12 months. President Ramaphosa grants Zuma remission, which Zuma argues altered his sentence from
Yeah.
15 months to 3 months. Therefore, he's no longer qualified.
Yeah.
This is going to be a big question on the substance of this case. What are your thoughts on that? Because I think it's a fascinating question of interpretation.
It is a fascinating question of interpretation, and this is where Mdumeni is going to come into play. That's the case on interpretation, because it applies to context, it applies to intent, it applies to the literal meaning. And if you think about what the second judgment agreeing that Zuma should remain on the ballot said, it actually focused on this. So I'm just trying to find
which
it here.
happens actually to be the majority on this issue.
Yeah.
Because there are 3 judges.
Yeah, exactly. Which happens to be the majority on the issue, because there are 3 judges when they're looking at this. Look, I think that when I think about it, it makes sense that you should be able to make this type of argument. I don't think that a pardon should be the only thing, because if we acknowledge that a pardon is a legitimate way of expunging a record for the purposes of these considerations, why would we say that a remission is different? That your sentence was reduced, and if that then ended up being the time you served, you became a free man, why would we then keep considering the remaining months as being part of that particular sentence? I think that I'm persuaded by the arguments that were made. In general, my disclaimer here is I'm persuaded by this because of the arguments that were made, but also because I really think that this whole thing should never have happened in the first place. If I had said Zuma has committed a crime as a Constitutional Court judge, I would have sentenced him to 6 months, right? And avoided some of the things that were, and I would have given an option of a fine, maybe even R1 million or whatever, to make sure that it's clear that I frown upon the contempt of court, but I wouldn't have chosen this. And even the fact that we know the remission in and of itself was a strategic decision made by the president and his team to say, hey, we can't arrest this man again. In pragmatic terms, realpolitik, if this man goes back to jail and he dies in there in an election year, this is going to be a disaster. Zuma is an old man, he's 82. Like, even though he seems like he's vibrant on the campaign and you can do a lot at 82, you can do a lot at 72, whatever, you are more susceptible to certain diseases. And if you change your environment a lot, that can affect you. And remember, we're in a COVID period at that time, and we know that older people are susceptible. Prison is not an environment that you send old people to, right? And looking at the original set of decisions, my whole approach to this is trying to rectify the anomaly, which is why I would even lean towards an interpretation which favors the argument that remission does expunge this. The other thing is that I'm aware of the contradictions, that people who have committed assault with grievous bodily harm, like Mandla Mandela, were actually able to go to parliament and serve. So our interpretation around who do we want in parliament, who do we not want, I think also needs to be re-examined. So I lean towards the argument, but that's partly because I already think that the original judgment caused a lot of these problems, and this court has an opportunity to fix the mess that they created. But I've also been just thinking about where is the rehabilitation side of this equation? So, for instance, Malcolm X committed a lot of crimes as a young American. He was breaking into people's homes. He was doing all kinds of stuff, criminal activity. But as he approached 40, he was a totally different man. He was a man who was a civil rights activist. He was working for the people. He was assassinated, unfortunately. But I thought about it, I said, should Malcolm X go to parliament or to Congress if let's say we were in the 70s and he hadn't been assassinated? On the basis of a criminal conviction, he would have been precluded if we're using our system. But is that right? This is now me going even beyond the conversation, because it is in the Constitution. It's clear. But I wonder about...
On that point, I think that's a really important illustration of what you were saying about earlier. Because if people are thinking about Zuma and their antipathy towards Zuma, then they would say, of course, lawbreakers must go to jail and all of that and never come to parliament. But the constitutional project, if we exclude Zuma right now, has always been about expanding political rights, enlarging them. And the court will have to think about not just Zuma, but what they're saying about the importance of the right to stand.
Yes.
And so if they undermine that right in Zuma's case, they may end up constraining it in other cases that end up not enlarging political rights, but actually contracting them. And I think there's that deeper philosophical question outside of Zuma's political issue.
How can a rehabilitated person serve in public office and do so genuinely?
And how much do we constrain the rights of those who have been convicted? And in doing that, might we limit political rights more generally?
Yeah. And let's say for argument's sake that Gayton had committed his crimes 7 years ago, right? And that the record is not expunged or whatever the case may be. Would some people not want him in parliament? Is it not worthwhile to have him in parliament, regardless of the fact that he used to have this past life? What is our commitment to rehabilitation? Because we are saying that we have a correctional services, a system which is designed to reintegrate you. So you stole a car when you were 19. You went to prison. You served your time. You rehabilitated yourself. You passed matric. You did your LLB. At what point do we then say, no, but you can't go to parliament forever? At what point does that seem as if it's an illegitimate decision? I saw it some on social media. Guy who had been a prisoner was now a judge in one of the courts because he was able to rehabilitate himself to that extent. And I think that question for me exists to say, actually, is this 1 year rule even fair? 12 months, if you will. And also, it doesn't specify types of crimes.
Yeah, just it uses the sentence as a proxy for seriousness.
Yes, and I think maybe there needs to be a clarification about which vices do we definitely want to exclude?
Yeah, exactly.
From public office.
Yeah, because
but which ones are acceptable to rehabilitate?
Exactly. Like you say, we can probably agree on things like murder.
Yes.
Egregious sexual crimes, etc.
Yes.
But when we come to contempt of court, where there is no...
Especially a political contempt of court, because Zuma was, in his mind, making a political statement.
Yeah, sure. Which
and trying to hold Justice Zondo to account for the fact that they have a relationship as according to him. So some of the stuff he did, and I mean, I'm cutting your train of thought, but if you think about it, when it was interviews for the office of the Chief Justice, I don't know if you saw some of those headlines where they said Zondo admits to having a relationship with Zuma. But at the time where Zuma made the statement that I know you and in fact we have a relationship and you shouldn't be here. The thing about Jacob Zuma sometimes that he withholds information for his own convenience and he wants to drop bombs, to make kak, so to speak. And he should have said that at the beginning. And then that issue gets travailed. But what I'm trying to say is that he changed the answer at a later stage, right? And what Zuma was doing there was not a pure contempt of court because he went. It's not like he never went at all. He did go, right? It was the second time where he was like, look, I think I need to make a political statement. That's not the same as just contempt.
I think also we have to consider that civil proceedings were used here. So again, murder, just egregious, terrible crimes. You know that someone would have had all their rights and the court would have found beyond a reasonable doubt with the benefit of that evidence. Where you have a very long conviction on the one hand and civil proceedings on the other, there's a question for the court. Is this the same thing as a very obvious, terrible, normal crime with normal procedure?
I think if it was anybody else other than Zuma, and we have to be very careful to understand that rights do not exist for the best amongst us. They're not for Siya Kolisi. They are sometimes for the worst amongst us, so that we say, we will protect this person because we know the arc of human history has proven that without these protections, we become the worst that we can be, which is why even murderers are afforded protection, legal protection, in that they can get someone to argue, they can get legal representation. They don't just get there and get stoned or sent to the gallows. We do that also to make sure our system has integrity. With Jacob Zuma, what I've seen, and I'm not a supporter of Jacob Zuma, but I'm a
Sure.
defender of his rights.
In fact, you're at some rallies calling for him to fall.
Oh
at
man,
some
you should have
point.
seen me.
Weren't-
Fees
weren't-
must
weren't
fall.
we all?
Fees must
Yeah,
fall.
yeah.
I was there arguing on all of the platforms that Zuma must go. And I maintain a lot of those arguments.
Sure.
But at the same time, we mustn't be so lost to the fact that, hang on, something funny is happening here. And this is why I think when I read Theron J and Jafta J's dissenting judgment, I agreed. And I have not been swayed yet that they were wrong. I think they didn't have the numbers in the room, but I think they had the moral and legal argument. But having said that, my caution around everyone always adding the bad Zuma side to their arguments is that it so clouds their judgment. It really does. And we need to then ask ourselves, would we be comfortable with all of these events that have unfolded in the way that they have if it was someone else that we like? Not necessarily Julius Malema, because he's also a controversial figure, or Jacob Zuma. What about Siya Kolisi? You like Siya, right? What if it had been Siya? What if it had been your favorite professor there at UCT? What if it had been Gift of the Givers, right? Let's say Gift of the Givers had done something in Gaza that then was illegal in South Africa, gets convicted, 15 months, and then now you can't run. Would you have been comfortable with everything that's happening here?
You know, funnily enough, Prof. Pierre de Vos, who I think has made important contributions to constitutional law as well, wrote an article about Zuma's remission.
Yeah.
And he said it extinguished the sentence, but that was last year.
Yeah.
So it'll be interesting to see, you know, the common opinion before this case has been remission extinguishes a sentence.
Yes.
Right? And
because they didn't know there was going to be an Mkhonto party, some of the people.
Well,
now that there's Mkhonto issues, people are like, wait a minute, does it really? Did I mean it? I mean,
exactly.
You know, interpretation. Let's let the court decide. The court that hates that guy. If they rule, hey man, it is what it is.
Yeah,
and we mustn't be afraid. Legal scholarship has never been afraid to re-examine. And us, of course, this is a preview, but even to pre-think, there's nothing wrong with that. I think also now there's this attitude that thou shalt not think about this until
absolutely.
XYZ person has said something. Like, what is this gatekeeping of thinking? Let's debate. Let's convince each other. Let's think. You know, in law school, I always was irritated by the fact that I had to read dissenting judgments. And I was always like, these things have no authority. Why do I have to learn them? But I found that I learned a lot about law from the dissenting judgments. And later on, you would find that even other courts would be persuaded by those same dissenting judgments and rule in line with those dissenting judgments, sometimes higher courts, etc. So the dissenting judgments had academic value to the point where my lecturers wanted to hear from me what I thought about the dissenting judgment. I always saw Jafta there. I'm like, this guy's always disagreeing, making my law studies longer. Because not only do I have to read the main judgment, now I got to read what Jafta had to say. Every time Jafta has things to say, but you learn a lot. You learn a lot. And now all of a sudden, we are seeing this attempt to silence legal thought, opinion, dissent, as if this is not what the legal fraternity is all about.
Absolutely. I agree with that. And I think to some extent, I don't know if it's premeditated, but when we look at the public and the mainstream media view of this, they will tend to invite the same voices. And then it starts to feel like there's a chorus. It's actually just 5 people, but it feels like there's a chorus. You will see strategic leaks of, for example, arguments, but only one side
of the argument. Only one side of the argument,
so
not the other side.
Exactly. And it really takes the public for granted. And look, the IEC may well prevail, right? And the court may come up with cogent reasons why they prevail. And we know that, for example, Advocate Mugai Tobi is a brilliant legal theorist. And the analysts on the other side of this case may well be right. I have a problem, though, with the media never giving the other side of the argument
attention.
Equal oxygen. And I think we do need to correct that to some extent.
I think you're right. And in fact, this extends more broadly now to a lot of the things I've seen on TV. What often happens is they get one person on an issue where there is controversy and dissent baked in.
True.
And where experts may disagree.
Sure.
And I find that they have killed the culture of intellectual debate on mainstream television in a way that I really think is unhealthy. If you know that there are two views, one that is favorable to the IEC arguments, one that is favorable to Zuma, get two legal analysts to speak there. There's not a shortage. There are 26 universities in South Africa. All of them have got constitutional lawyers.
Yeah.
All of them have got PhD students. There are so many people practicing law in South Africa. And in fact, you may help those people because some people are trying to get coverage for their businesses. Platform more people and let the public have a full understanding, not a one-sided understanding of the issue. The media, I think, has lost a lot of credibility by walking away from this because they need to be committed to scholarship. They need to be committed to intellectual debate. What other forum is best suited for these kind of extrapolations and discussions than mainstream media? But now it seems as if mainstream media is only interested in managing the public perception as opposed to allowing the public to develop its own perception.
And that's why everyone was shocked by the Electoral Court order, right? Because it had been, foregone conclusion, Zuma's going to lose because people had only heard one side. And suddenly, when the court found against Zuma, people thought, like, is the court crazy? Is there something? No,
and
it just
if you
happened
had
there were
been
other
checking,
arguments.
some people online were saying, no, he's got a strong case.
Sure.
He's got a strong case. These are good arguments. People who watch the case were like, no, it does look as if Advocate Mpofu argued well in this particular case, and I'm persuaded. But when you don't have this post-case analysis, if you look even with the Trump issue, they are getting panels. They are getting different perspectives.
Sure.
You cannot and should not have a choir of cheerleaders discussing issues of this nature on national television. It's a dereliction of the duty of the media.
Mighti Jamie, thank you so much for adding a different perspective on this case and helping us preview and understand it. Let's have a look at what happens at the court, and hopefully we'll also do some post-case analysis as well.
For sure. This is South Africa's version of the Drake versus Kendrick brief right now. Whatever happens on Friday, woo, this is that.
South African family matters are under discussion.
There you go. There you go. Thanks so much for having me.
Spread the fire. Of course, like, share, comment down below whether you agree or disagree. Let's have an interesting conversation and debate about this case. Let's go beyond the mainstream views. And you know this is the best place to analyze South African politics and this case. Stay tuned to SMWX and help us get to that 100,000 subscriber mark before the 29th of May.
Coming soon. It's coming soon.
Oh, yes. Aye.